Welcome in. I am Dean Reuter, Senior Vice President and General Counsel of the Federalist Society. I'm happy to welcome you all here today. It's great to see so many of you here coming to work, at least on a weekday. Apologies are sent to you from Reg Brown. Reg is, of course, the DC Lawyers Chapter President. He could not be here with us today. He's on something that he called vacation. So, but he's probably taking a deposition, I'm sure of that. Special recognition to, is Miguel here? I see Miguel. He's not at the table he was supposed to be at, but special recognition to a couple previous speakers in our Supreme Court Roundup series over the years who are with us today, Miguel Estrada and Ted Olson. So thank you, gentlemen, for being with us. Today's business, it is my honor to introduce today's speaker, who's going to speak to us for about 45 minutes, 50 minutes, and then take questions. Make sure your questions are questions, if you would, please. But today's speaker, Paul Clement, a Harvard Law School graduate and a veteran of over 100 U.S. Supreme Court arguments, which, to give you some perspective, is just a hair over 100 more U.S. Supreme Court arguments than I have made myself. So I stand in awe of Paul Clement. He has served in all three branches of government during his career in a lot of different locations, law firm positions, et cetera, et cetera. And that, of course, reminds me of a very brief story. Now, my grandfather had an old-time address book that my grandparents kept by their old-time telephone in their old-time living room. And for the younger folks here in the room with us today, I can attest to the fact that houses used to come with telephones that were wired into the walls with cords that kept you tethered close by, and you had to write things down back in the day, addresses and phone numbers. Anyhow, my grandparents had this loose-leaf telephone book that included all their friends and family, phone numbers, addresses, sometimes birth dates. You've seen the books like this. They're the small black ones, alphabetical, with tabs for every one of the letters, creating separate sections, except for X, Y, and Z that were all scrunched together for some reason. But the pages in my grandparents' book were a mix of pen and pencil entries, different inks used over the years as additions and edits were made, old addresses lined through and new ones adopted as people moved from place to place. One name, a particularly mobile person, I don't remember his name, Bob Smith or something, that page that he was on was just a smear. There was a first address that was lined through and then replaced, a second address lined through, a third address erased. There were marginalia, all sorts of blots on the page. My grandfather was the custodian of this book, and he made all these changes personally, and he always seemed vexed at having to make these changes and these edits, like he was going to run out of space on the page, or the pages were losing their tidy appearance, or maybe, like some of us, he just didn't like change. Now, I'm not sure how my grandfather would have handled Paul Clement. I already mentioned that Paul went to Harvard Law School, and I should have mentioned he graduated magna cum laude from Harvard Law School. I don't think they had that at my law school. I don't know what that is, but I graduated thank you laude. So, yeah. Before Harvard Law School, though, there was Georgetown undergrad for Paul, and after law school, there was Cambridge. So those addresses would all be in my grandfather's address book and then cross through. Then he clerked for Judge Silberman and then Justice Scalia, creating more addresses. He was chief counsel of the U.S. Senate Subcommittee on the Constitution, Federalism, and Property Rights, another address. And then the same with the SG's office, where as principal deputy and then SG, where in my mind, Paul revolutionized the practice by reaching down into lower courts and shepherding cases so they arrived at the high court in the best fashion possible, with the best record and the best arguments preserved. But of course, in my grandfather's mind, this just merely created another address and phone number. Paul was even, by some accounts, and I've never asked him about this, but according to some accounts, he was acting attorney general for as much as 24 hours once upon a time. I'm not sure that it would even have gotten into my grandfather's book. And then about 15 years ago, some of you might remember or recall that he went into private practice at a big law firm here in DC. He left somewhat abruptly and went into practice with Viet Din at the Bancroft Law Firm, where the team did great things and created yet another address. Then Bancroft famously absorbed the Kirkland & Ellis firm. Now, my apologies go to Reg Brown. But oddly, I thought Bancroft kept the Kirkland name. So, more recently, Paul left that firm and started his own law firm, Clement and Murphy, here in Washington, D.C., where he is, of course, thriving at yet one more address. So, Paul, rest assured that whatever your temporary address, you will always have a home here at the Federalist Society. So please join me in welcoming Paul Clement.
So thank you, Dean, and thank you for highlighting that I can't keep a job, but c'est la vie. At all these various locales recently, I've had the great privilege of arguing some cases in front of the Supreme Court, and I'm happy to be with you today to talk a little bit about this most recent term, and particularly happy to be here with Miguel and Ted, my illustrious predecessors at this podium, but and with Ted in particular, that all those sojourns to the lower courts, that wasn't my idea, that was Ted's idea. So it's great to be with you all. So let me just start with a couple of overview thoughts about the term that's just finished. In some respects, one of the interesting statistics to me is that this past term, the Supreme Court decided 58 cases on the merits. And that is the fewest cases they have decided in the post-COVID era. And it's a marked step down in terms of the number of cases, even from the Roberts Court average. The average number of cases decided by the Roberts Court across terms has been 75. So when you're down to 58, that's about 25% less than the Roberts Court. And of course, the Roberts Court was what we thought was the absolute bottom of the barrel, that given if you count up the argument slots, that you really couldn't go much below 75 arguments in a term. But turns out you can do just 58. You'd think with just 58 cases to decide, the court would be just lightning fast. And so what you'd lose in volume, you'd make up for in speed. But it turns out that's not true either. The court this year was on a century slow pace in deciding the cases, such that by the beginning of April, the court had decided just 9 cases total, which is pretty astonishing. But here's the statistic I actually find the most interesting, because you just wouldn't get this number out of any of the end-of-term wrap-ups from the major newspapers in this country that were quick to remind us of how divisive the court is and how unpleasant some of the exchanges between the majority and the dissents have been and how conservative this Roberts Court is. Turns out that 30 of the court's 58 cases, so more than half, were decided unanimously. Now, 1 or 2 of those are a little misleading in that there's a 9-0 decision on the disposition, but there's sort of 5-4 on the reasoning. But for the most part, these unanimous cases are actually unanimous cases. And the idea that this sort of divisive, dysfunctional, ethically challenged court is actually deciding over half its cases unanimously, I think is really a pretty remarkable achievement, and sort of suggests that there's something very different going on kind of behind the scenes at 1 First Street than we're reading about in the press. And of course, to state the obvious, that more than 50% unanimous number is all the more impressive when you remember how the court gets this paltry 58 cases. It takes 58 cases that in the main are cases where lower federal courts have already divided and come to disparate decisions and created a circuit split, and that's why the court gets involved. So the fact that in essentially half of the cases that the lower courts have divided, the Supreme Court itself is unanimous, at least as to the disposition, is a pretty remarkable fact. One other thing just to note, and I'll come back to this at the very end, but it's not just the number of cases that are down, but the number of petitions. And for a number of years, the petition rate would stay pretty much the same, and the court would take a few fewer cases every year, which I think I can speak for Miguel and Ted and others really bothered me. That it's denying historically large rates of petitions and the like. But this year, the number of petitions were also down rather markedly, and you can ask why that is, and I'll try to provide an answer at the very end. And then the last thing I'll say before talking about specific cases that were decided this last term is one of the oldest adages in Washington is that every time you add a new justice to the court, you get an entirely new court. And I think that's one of the oldest adages in Washington because it's right. The 9 justices are a bit like a multi-membered old married couple. They're stuck with each other for the rest of their lives. And so if you essentially add a new personality to that mix, it's not just that there's one new justice. It changes the personalities and the interactions among and between the justices in a way that's pretty profound, I think. And I think you saw that this term in that if you just kind of looked at this superficially, Justice Jackson replacing Justice Breyer sort of should have been a non-event. I mean, after all, she clerked for Justice Breyer, so you'd think you're getting a very similar justice. And I think there were some differences in terms of the dispositions in a couple of cases, one or two that I'll highlight. But also, I mean, Justice Jackson, to say the least, came ready to ask questions. Many of you have seen the statistics that show that, on a sort of per word, per justice basis, that Justice Jackson, although the most junior justice, really dominated the argument. And it certainly affected the dynamic of the argument from a practical standpoint. As an advocate before the court, I mean, the combination of the new justice and the new format has really made the arguments much longer. If I weren't about to tell you about the affirmative action decision, I might think Seth Waxman was still up there answering questions in that oral argument, which went, I think, close to 5 hours. Well, let me transition then from the overviews to specific cases. And I will start with the affirmative action cases, which I think were probably the most closely watched cases of the term, or certainly in kind of the top 3 for sure. The court, as I would venture to guess everybody in this room knows, ruled 6-3 in the North Carolina case and 6-2 in the Harvard case that the affirmative action programs of those 2 universities were unconstitutional, essentially a violation of the Equal Protection Clause when it comes to North Carolina and a violation of Title VI when it comes to Harvard. The court, in an opinion by the Chief Justice, identified 3 principal defects with the programs and the way they were operated. The first is my favorite. The court basically said that one of the faults of the universities was they didn't operate their programs in a way that made it easy for the court to apply strict scrutiny. So essentially, they'd inconvenienced the court by making the court's job very difficult by having sort of an amorphous, compelling interest that you couldn't really do strict scrutiny to. But I think the second and third reasons that the court identified are probably closer to the real nub of the decision. And the second thing that the Chief Justice identified is that by trying to use affirmative action essentially to benefit certain racial groups, in practice, what the universities were doing were specifically disadvantaging Asian Americans. And the court said that the use of race as a stereotype or a negative for a discernible group of applicants based on their race was a violation of the equal protection principles. And then the third point is that the court faulted these programs for having a lack of a logical endpoint. Now, I suppose the universities could have pointed to Justice O'Connor's opinion in Grutter and Gratz and said, well, actually, they do have a logical ending point. They end in 25 years, and we still have 3 or 4 years left. But I think the gist of this is the classic use of race that satisfies strict scrutiny is one where you are remedying a past identifiable example of racial discrimination. And in those kind of contexts, you would think that the remedy for a past violation would have a logical endpoint. I mean, if a local fire department discriminated on the basis of race for 10 years, maybe it would take 10 years of a program to remedy that, but there would be a logical ending point. And the court perceived no logical ending point in the programs as they were operated in both North Carolina and Harvard. At the very end of the Chief's opinion, there are a couple of sentences that I think are a harbinger of a lot of litigation to come. At the same time that the chief emphasized that these programs were unconstitutional and the use of race generally was unconstitutional, he did say that it was okay for the universities to consider an individual's applicant's essential story about how race affected their individual life, that they had to overcome racial discrimination or the like. And then the very next sentence he said, but of course, you can't get away with pretext, and you can't just use this kind of individualized consideration as a loophole to get away through the rest of the decision. I think there will be a lot of litigation over those couple of sentences. I also think that further litigation here is almost inevitable. And I think I really do almost pity a college admissions officer or a law school admissions officer, because the problem they face is that they have internal constituencies that are absolutely dedicated to the idea that things should not change because of this decision. There are parts of the university community that think the decision is 100% wrong and things should not change at all. And I think there are some universities that will react to that, will appease that particular internal constituency in a way where you're going to see this landmark decision and nothing's going to change. The numbers are going to not change, and they're going to be very stable across year to year. And when that happens, lawsuits will follow. And the other thing that will follow that I think will be fascinating in a lot of these cases is this little thing called discovery. And I think that it's going to be very difficult for some of these universities to have an internal process that doesn't lead to some things that in any other context would be absolutely devastating evidence that this was all an intentional racial discrimination and intentional massive resistance of the Supreme Court decision. So I think that will be very interesting to watch. The other thing that I should mention in terms of going forward, the reason that Harvard, even as a private institution, was involved in this case, of course, was because it accepted federal funds under Title VI. There's another title, it's called Title VII, that applies to employers across the country. And I think that with this decision, there are some employment practices that are pretty open and notorious by some corporations that I think are going to be the subject to litigation with this case cited prominently. And it'll be very interesting to see how those cases come out and whether they're any different. So because the decision and the affirmative action decision was very closely followed, and it came out at the very end of the term, along with the student loan case and the 3038 creative cases that I'll talk about, sort of at the end of the term, there was this kind of crescendo of opinion that suggested, boy, this court is so conservative, it's just as conservative as last year. And I think it really ignored a couple of the other cases that the court had decided in the month before that. And I just mention a couple of them, because two of them, interestingly, involved challenges to the use of race. And one of these was the Alabama redistricting case, Allen against Milligan, and the other one was the Halland against Bracken case that involved the Indian Child Welfare Act. And in both those cases, the court had an invitation to strike down a major piece of federal legislation as unconstitutional because of its use of race or consideration of race. Alabama, and I'm quite sympathetic for what happened here, but I think Alabama, because they got a stay of a lower court decision that struck down their redistricting plan, I think they felt like that they almost had at least a narrow victory in the bag because they'd gotten the stay the term before. And I think as a result, they decided to kind of swing for the fences in their arguments in this case and ask the court essentially to hold that Title II of the Voting Rights Act is unconstitutional. And the court, by a 5-4 decision, not only refused the invitation to hold Section 2 of the Voting Rights Act unconstitutional, refused the invitation to overrule the so-called Jingles factors, but actually ruled against Alabama and affirmed the lower court decision by a 5-4 decision where the Chief Justice and Justice Kavanaugh joined the liberal justices over the dissent of the other conservative justices. And I point this out mostly just to say that this court is a much more nuanced institution than you might get from just reading the newspaper headlines. And you also saw that in the ICWA case, the Indian Child Welfare Act case. That was a case where the court had a number of challenges before it to the statute, including some anti-commandeering challenges and Article I challenges, but the court specifically declined to reach an equal protection challenge to the statute. Now, I think in fairness, it's reserved the question for another day, but I do think it's noteworthy that there were these two cases involving some of the same legal doctrines as in the affirmative action cases, and the court decided them quite differently, and that's a nuance that, at least in my reading of the end of term coverage, got completely lost. Another case worth, I think, mentioning is in this vein, and I'll talk about it before going to 303 Creative, just because it keeps us in the election law area. But there was the so-called independent legislature case, or the Moore against Harper case. This is a case that has its roots both in the Rucho decision, which, as a matter of federal law, said there were no justiciable limits on partisan gerrymandering, and quite frankly has its roots in the Bush v. Gore case that Ted argued, and a lot of people in this room were involved in one way or another. And the reason I say it has its roots in both is because with the Supreme Court saying that, as a matter of federal law, they're not justiciable standards for partisan gerrymandering claims, it definitely left open the possibility that a state Supreme Court, under its own state constitution, could discern some, what it perceived anyways, to be judicially manageable standards for these claims. And sure enough, when the Democrats in North Carolina didn't love the map that the Republican legislature drew, they went to the North Carolina Supreme Court that, at least temporarily, was controlled by a Democratic majority. And that Democratic majority on the North Carolina Supreme Court discovered the missing link, the Rosetta Stone of partisan gerrymandering, and said they could decide these cases, and found the Republican map was unconstitutional. Now, the Republicans in the legislature went to the Supreme Court on the theory that the state Supreme Court is not in a position to overturn a congressional redistricting map on state constitutional grounds, because the Elections Clause in Article I specifies that that authority belongs to the legislatures of the state, not the state Supreme Court. And funny enough, there's a postscript to this. So what happens next is the case is briefed and argued. There's much hand-wringing on the left about the independent legislature theory being the end of judicial review as we know it. But then there's an election in North Carolina, and the state Supreme Court flips to the Republican side. And the Republican state Supreme Court apparently lost the Rosetta Stone and rejected the partisan gerrymandering challenge to the plan. And there was 2 rounds of supplemental briefing where the parties suggested, some of them suggested, that the case was now moot. And so I say all that to say the Supreme Court had to work very hard to reach the merits in this case. I'll spare you the details, but the court worked very hard to get to the merits of this case. The Chief Justice did get to the merits of this case, and joined by, again, Justice Kavanaugh, and this time Justice Barrett as well, rejected at least the form of the independent state legislature doctrine that was presented to the court in this particular case. It did sort of reserve judgment that there may be extreme cases, read Bush v. Gore, where the state legislatures, the state Supreme Court so deviates from the normal order of things that there's a problem under the Elections Clause. But as a general matter, it rejected the argument that the state Supreme Courts don't have any role to play in these cases. So another case over the dissent of the Justice Thomas, Justice Alito, and Justice Gorsuch that certainly doesn't fit the pattern of the description of the court. And I think those 2 cases, the Alabama case and the Moore case, are worth dwelling on just because they were the focus point of so much attention on the left side in terms of what this court is going to do to voting rights. And it turns out at the end of this term, the supposedly monolithic conservative Supreme Court essentially left all that stuff exactly where it was at the beginning of the term. Well, here's an area I'll move next where the law has shifted a bit, and that's the 303 Creative case. And this case has its roots in the Masterpiece Cake Shop case. And most of you will recall a few terms ago, specifically in the last term that Justice Kennedy was on the court, the Supreme Court essentially had the same basic conflict before it, which is a conflict between sort of state non-discrimination public accommodation laws, which say that businesses can't discriminate on the basis of race and sex, and more recently, sexual orientation. So those laws, on the one hand, conflicting with the free speech or free exercise rights of somebody who doesn't want to bake a creative cake on behalf of a same-sex couple, or in this case, doesn't want to use their sort of creative process of creating websites for weddings for a same-sex couple. Now, as you'll all recall, the Masterpiece Cake Shop kind of fizzled. It was a fascinating thing to watch. I was expecting it like few cases because it's Justice Kennedy's last term. He seemingly had the deciding vote. If there's two principles of Justice Kennedy's jurisprudence that I think are kind of most notable, it's protection for same-sex couples, sexual orientation claims on the one hand, and a complete dedication to free speech principles on the other. So what is he going to do? His two favorite principles are coming into conflict. Is he going to blink? Which one's going to take precedent? Instead, he punted. And the whole court punted, of course, Masterpiece Cake Shop, by focusing on the record that was compiled in the Colorado Civil Rights Commission, and one of the commissioners said some nasty things about religion, and that was the basis for the court holding that there was a free exercise problem in the case, and they didn't have to decide the issue that everybody had filed amicus briefs to have them decide. So the issue doesn't go away. The issue comes back to the court this term in the 303 Creative case. And I will say just this before talking about what the court decides. This is not the first time that the Supreme Court actually considered a conflict between the free speech clause and a public accommodation law. The court actually decided that issue 20 years ago in a case called Hurley, which involved the St. Patrick's Day parade in Boston, and the parade organizers did not want to include a sort of gay Irish pride group. And that case went all the way to the Supreme Court, and the Supreme Court decided unanimously that the free speech rights of the parade organizers essentially trumped the application of the public accommodation law in Massachusetts at the time. So maybe it's not a surprise that the Supreme Court, when it finally teed up this case for decision, decided 6-3 in favor of the website designer and said that the free speech clause rights of the web designer trumped the Colorado non-discrimination law. And the court's decision, not surprisingly, relied quite heavily on the Hurley decision, and this was a 6-3 decision. So just a couple of additional thoughts about this case. One is, it's noteworthy that the court decided this case just on free speech grounds, not on free exercise grounds, and that was a decision it made at the cert stage. So the 10th Circuit had ruled against the web designer on both free speech and free exercise clause grounds. The cert petition tried to get both issues before the Supreme Court, and the Supreme Court limited the cert grant to the free speech issue. Why is that? Well, we don't know for sure, but my guess is that if the court took up the free exercise issue in this case, it would have to wrestle with whether it should overrule the Smith decision. It had wrestled with that question just a few terms before in the Fulton against Philadelphia case, and it did not wrestle with it satisfactorily. And I think the court thought it was just sort of too soon to revisit that issue, so they kept the case focused on the free speech case. The other thing that's notable about this case, and I don't know if there's a direct causal link here, but as I mentioned, the Masterpiece Cake Shop kind of went sideways based on the record before the Colorado Civil Rights Commission that was assembled in the context of the enforcement action against the baker. The litigants this time around decided that they weren't going to take any risk that one of the commissioners would say something silly that would derail the case, so they brought the case as a pre-enforcement challenge. They went into court and said there's a possibility, a strong possibility, likelihood that this law will be asserted against the web designer. The Colorado essentially stipulated to that fact and a number of other facts, including that she was engaged in expressive activity. And on that stipulated record, in a pre-enforcement challenge, the Supreme Court decided the case. That wouldn't be noteworthy, except that after the decision, surprisingly, like the left decided that they didn't like pre-enforcement challenges. And they were outraged that this web designer didn't wait for the commissioners to come knocking on the door, and somehow this was all inappropriate and an abusive process. And there, if you're on the left side of the political spectrum, there are a lot of fair reasons to sort of critique this opinion and criticize this opinion. But the fact that it's a pre-enforcement challenge is not one of them. And I do think people on the left sort of need to be reminded that cases like Epperson, which successfully challenged Arkansas's state law about teaching evolution in school, a little companion case to something called Roe v. Wade, namely Doe v. Bolton, also a pre-enforcement challenge, NAACP v. Button, pre-enforcement challenge, Reno against ACLU, those mean, nasty people in the ACLU cocked up a case against the federal government, didn't even wait for the enforcers to come knocking down their door. So it just goes to show that the level of discourse about Supreme Court decisions, unfortunately, may be at kind of a new low if the court is being criticized for sort of making up a case by taking a pre-enforcement challenge. Staying in the realm of the sort of First Amendment, as I said, the court went out of its way to make sure that 303 Creative was not a free exercise claim, but they did have one sort of statutory construction claim before them that was more of a free exercise case, and this is the case of Groff against DeJoy. And it comes up in a kind of a recurring issue about religious liberty, which involves Sabbath observation and having a day off. And the nub of the issue here, and the Supreme Court's now considered it twice, is that a lot of religiously observant people want to take their Sabbath day off and say they don't work that day. And for a lot of people, that means not working on Saturday and not working on Sunday. And of course, less religious people have a word for Saturday and Sunday, and they call that the weekend, and they too don't want to work on the weekend. And so if religious people are able to take off Saturday and Sunday as a matter of their sort of statutorily protected rights, it tends to make some of their less religious coworkers grumpy. And that is, in a sense, the dynamic that has led to two Supreme Court cases. And the first time the court got this, it was back in the 70s in a case called TWA v. Hardison. And in that case, it happened to be in the context of a negotiated seniority system in a CBA, which made the case, I think, even a little more difficult for the religious claimant. But nonetheless, the court was wrestling with some statutory text. And as was often the case back in the 70s, they didn't spend a lot of time with the text while they were wrestling. Because the relevant text here is that under Title VII, for religious discrimination, it's not enough just not to discriminate against people just based on their religion. You also, according to the text, have to reasonably accommodate their religious practices and beliefs. And that was defined by statute as, you essentially had to give the accommodation unless it imposed, quote, an undue hardship on the conduct of the employer's business. Now, as I say, the court in the 70s thought that undue hardship was synonymous with anything that was more than a de minimis burden was an undue hardship. Now, those things seem very different to me. Non-de minimis seems like essentially about the lowest thing in the law, and an undue hardship seems like a fairly significant thing an employer would have to show before they did not accommodate their religious exercise. But nonetheless, that was the decision, and the lower courts had pretty dutifully applied that standard such that as long as the employer could show that there was anything more than a de minimis cost, the religious claimant would lose. So this goes up to the Supreme Court, and I think a lot of us were looking at this case as a case where the court might overrule Hardison. But instead, the court unanimously, and I'll get back to that in a minute, but unanimously essentially reconceived Hardison and said, well, maybe the decision wasn't quite as bad as it looked at first blush. And there's some other language in the opinion that says something other than non-de minimis, and the court, without overruling Hardison, established the new standard, which is that an accommodation must be granted unless it will result in a substantial additional cost in relation to the conduct of the business. And that sounds a lot more like undue hardship to me. So this, I think, is a vast improvement. The other thing that the court said unanimously, which I think is in some respects even more important, is it said that just having disgruntled coworkers is not enough for an employer to show an undue hardship. They have to essentially show that the effect on coworkers is problematic enough to have a negative impact on the employer's business, which again is the statutory term, so that's nice. But the important point is, in a lot of these lower court opinions, all the employer had to do is to say, well, other people wanted the weekend off, and that's enough, so they were disgruntled, we win. And the court unanimously said that that's not the case. I think this opinion will have a fairly big effect in changing the law in favor of the religious employees. And I also think where the rubber's going to meet the road in future cases is not on taking the Sunday off or the Saturday off, but is taking the DEI training program off. Or taking the mandatory imposition of sort of pronouns off. I mean, I think those are the issues that are going to kind of resurface now in the lower courts. And I think the religious adherents are going to have a much better chance to prevail. And I will say, I mean, for the most part, I'm in favor of the court if it's going to overrule a decision to say that that's exactly what it's doing. I think that's better for the development of the law. But kudos to Justice Alito for making this opinion unanimous. Because I do think a unanimous decision in this area is going to have a more profound effect on the lower courts than a 6-3 decision would be. So I do think, in a lot of respects, this is a significant and important decision. So let me talk, I'm going to wrap up talking a little bit about administrative law, but before I do, let me talk about a couple of other areas of the law just briefly. The business docket is something that is of importance to a lot of us in this room. And there might be a naive assumption that a kind of conservative originalist court would be good for business. Maybe in the long run, but not this term. The business community and the chamber and the amicus briefs they filed had a relatively difficult term, and certainly a mixed term, but they lost some big high-profile cases. And they lost them at least with kind of interesting dispositions of the Supreme Court in terms of the division of the justices. So let me talk about 2 losses, and then I'll talk about 1 win. The losses, I'll start with Mallory against Norfolk Southern, which was a case about sort of whether there was a due process problem with essentially a state forcing a corporation to consent to general jurisdiction. So if you think about sort of personal jurisdiction, if you choose to think about it at all, but if you think about personal jurisdiction, the trend in the Supreme Court over the past sort of decade or so has been to cut back substantially on general personal jurisdiction, the idea that a defendant can be sued for something that happens anywhere in the world as long as they're in a state where they do a fair amount of business. The court really cut back on that a lot in a number of cases, including the Daimler case. And really kind of move things in the direction of, no, you got to show personal, specific personal jurisdiction. You have to show this is where, like, the accident happened. But there was this old Supreme Court case from 1916 called Pennsylvania Fire, and it suggested, or maybe held, that if you had consent jurisdiction, so if a company, when it registered to do business in a state, was forced essentially to check a box that said, by registering you agree to accept service of process for any suit that takes place anywhere in the world, that would be sufficient. And of course, it seemed really out of step with the thrust of the modern due process opinions. And so this went up to the United States Supreme Court this term. And the question was essentially, are you going to stick with Pennsylvania Fire, or are you going to align the due process analysis of these consent cases with the rest of your jurisprudence? It was a hard question. The court split 5-4. The 5 who ultimately said that we're not going to revisit Pennsylvania Fire, and it may seem unfair to get this kind of consent jurisdiction, but you're just going to have to get over it. Those 5 were Justices Gorsuch, Justice Thomas, Justice Alito, Justice Sotomayor, and Justice Jackson. And the 4 dissenters were Justices Barrett, Chief Justice, Justice Kavanaugh, and Justice Kagan. So this issue was sufficiently difficult and nuanced enough that it split not just the right side of the court, but it split the left side of the court in a very interesting 5-4 division. So, speaking of which, another big loss for business was the National Pork Producers case against Ross. And when the court decided to grant this case, there's a lot of speculation that this would be the case where even a relatively conservative textualist court was going to breathe at least a little bit of life into the Dormant Commerce Clause and a pike balancing in particular. And the reason for the expectation, I think, was that the California law was so crazy. because the California law was essentially a law that says that if you want to sell pork in the state of California, you need to process your pork and you need to treat the animals in a variety of ways that involve very extensive regulations about the circumstances in which the animals were fed and housed and transported. And what made that kind of outrageous is California, I mean, you might think all they do is eat tofu out there, and they can't eat foie gras, depending on the law at the time, which is tragedy. But they actually apparently eat a fair amount of pork. So like they're a big market, and so if you can't sell pork in California, that's a pretty serious problem. But California raises very little pork. Most of the pork in this country is raised in places like Iowa and other places that have a very different conception than Gavin Newsom about the humane treatment of animals that are headed for the slaughter. And so the extraterritorial effects of this law were enormous. And so there was this sense like maybe this is the one where the court just says like the state interest is so minimal and the extraterritorial effect is so great that this violates the Commerce Clause. But no, 5-4, the court said that not even that violates the Commerce Clause principles, including the extraterritoriality cases, which the court distinguished in a way that narrows those decisions compared to how I described them in a couple of briefs I filed over the last couple of years. So the court decided this case, again, 5-4. Again, the left and right side of the court both divided in this case. The opinion, again, written by Justice Gorsuch, again, joined by Justice Thomas. Again, maybe less predictably, joined by Justice Sotomayor. Kagan and Barrett make up the 5 in the majority, and the dissenters are the Chief Justice, Justice Kavanaugh, Justice Alito, and Justice Jackson, casting what I think is one of the more intriguing votes of her first term on the court. So I'll just say one more thing about these cases before turning to the one case that was a good result for the business community, and that is the obvious way to sort of think about the court and think about different wings of the court is to think about sort of the left versus the right, conservative versus liberal. But there are other ways to think about the court, and one, I think, important way to think about the court is, you sort of have the theorists and you have the pragmatists. You have the justices that will essentially drive the team bus right off the cliff if, that's where the text takes them. And then you have other justices that, fun's fun, but let's not die laughing. And I think in the context of this case, I mean, you sort of see that I think it's telling that Justice Gorsuch and Justice Thomas and Justice Sotomayor are in the majority in both of these cases. And in different ways, I think they probably fit more in that sort of drive the team bus off the cliff. And I don't think it's an accident that the Chief Justice and Justice Kavanaugh are the 2 justices that are in dissent in both of these cases. And so I think, especially for advocates who are, as I describe the job of Supreme Court advocate, it's to get to 5 for your client. And as you're sort of thinking about how to approach some of these cases, I think thinking about that division on the court is a useful way of thinking about it. So maybe it's a sign that the business community didn't have a great year at the court, that I think the biggest victory for the business community is the case that the court actually ended up sort of punting and not deciding, and that is the Gonzalez against Google case involving Section 230 of the Communications Act. And the reason I say that this was a big victory for the business community is that when the court granted this case, under circumstances where, I won't get into the details, but the court did not have to grant this case. I mean, they had an almost identical petition a few years ago written by the same petitioner's attorney in a different case out of the Second Circuit that was, kind of borrowed verbatim, to be honest. And the court denied that case, and they granted this case out of the Ninth Circuit. The dynamic here with Section 230 is this is part of the Communications Act of 1996. It's written to protect the internet in its nascent stage, but it's written in a kind of funky way that seems like it's a pretty narrow provision, and yet for almost 3 decades now, the lower courts have interpreted it to be a fairly broad immunity for internet providers, social media companies, and the rest. So when the court granted this case, there were kind of alarm bells through a lot of kind of high-tech companies and the like about what the court would do with this case. And in the end, because of the way that it resolved a companion case, Tomna, the court essentially decided that they weren't going to revisit Section 230. But I think it's more than a situation where they just didn't decide the issue, because I think from the oral argument, there was a real sense that the court kind of understood that it would be very hard to kind of go back to 1996 and just interpret the statute in a very narrow way, because this entire industry essentially has developed on a broader understanding of the statute. And that's not the way that this court addresses a lot of statutory construction issues. So I think it was a very noteworthy non-decision. And I also think, again, as kind of a practice tip, if you look at this case, the way that the sort of high-tech community was able to marshal just an extraordinary amount of amicus support from a variety of different contexts to really make clear that this would, really be a problem to pull the plug on the way that the lower courts interpreted this. I mean, whether it ultimately carries the day, whether the Supreme Court revisits this issue in a couple of terms, I don't know. But I do think that it's striking that the court was receptive to that argument in this particular case. So let me briefly talk about the criminal law docket. Tends to get a little bit of a short shrift in these kind of term wrap-ups, but every year, term in, term out, it's an important part of the Supreme Court's docket. I'll just talk about two cases that were among the 30 unanimous cases that the Supreme Court decided, and the two cases have a commonality in that in both cases, the federal government's broad interpretation of the criminal statute was rejected by the Supreme Court 9-0. And in both cases, the lower court was reversed by the Supreme Court 9-0. So the Second Circuit's lashing took place in the Simonelli case, which involves an idea that's been kicking around in the Second Circuit. And I don't mean to trivialize it by saying it's been kicking around because there are people in federal prison because this has been kicking around. But this is the so-called right to control theory under fraud statutes. It's like a kissing cousin of the honest services fraud, intangible services fraud. It's like not when you're taking money from people, but you're just not giving them all the information that they might have wanted, so they lose their right to control. So like if you tell somebody, they're trying to sell their guitar for $200 and but they're not sure who they want to sell it to you, and you tell them, well, I got a son who would just love that. He's just learning to play, so here's $200. Give me the guitar. So it turns out you don't have a son, but you really wanted the guitar and you wanted to pay $200 for it, which is all he was asking for. Is that fraud? Depends. If you ask the Southern District of New York, absolutely, go to prison. If you ask the Supreme Court, no, because the statute says fraud, and fraud, as the court has said in multiple cases, goes back to kind of common law notions of property, and they require something tangible, and you got what you paid for. So that was 9-0 decision by Justice Thomas. The Dubin case comes out of a different circuit, but same basic result. This is a case where the statutory provision is a prohibition on aggravated identity theft, and it specifically says that it's a felony to knowingly use a means of identification during and relative to a variety of crimes, including healthcare fraud. In the federal government's infinite wisdom, this meant that if you committed healthcare fraud and one of the forms had somebody's social security number on it, even though the social security number had nothing to do with the fraud, you were nonetheless guilty of aggravated identity theft. And again, the Supreme Court said, no, that's not what the statute says. That's not what the statute means. Again, 9-0, this time by Justice Sotomayor, and again, the lower court being reversed. So I look at these cases and I think that this is a court that is pretty dedicated across the board to giving reasonable scope to criminal statutes in a way that protect people's individual liberty. And I read these cases and their 9-0 results, and I think the lower courts still aren't quite getting the message. So I think this is a trend we'll probably see kind of going forward, but I hope sooner rather than later the lower courts do get the message. So just let me touch on administrative law and then take some questions. So the big kind of administrative law case on the court's docket this term, I think, is Biden against Nebraska, though you could also say this is just a statutory construction case. This is the student loan forgiveness case. The Higher Education Act authorizes student loans, and it authorizes forgiveness of those student loans in a few very narrowly circumscribed circumstances, like if you're in public service, if you're suffering certain kinds of disability, if you're bankrupt, or perhaps most obviously, if you're deceased. So the statute is quite specific about those narrow circumstances where loans can be forgiven. There was a provision added in the so-called HEROES Act that also gave the Secretary of Education the authority to, quote, waive or modify any statutory or regulatory provision in the event of war or national emergency. So, in the wake of kind of COVID, and it is true that during COVID, certain payment schedules and due dates were relaxed by the executive branch. But in the wake of that, when things were starting to return a little bit more to normal, the Democratic Party got the idea that we should forgive like lots of student loans. Maybe we shouldn't even have these things in the first place. They talked about some legislation, talked to some people in that. The Democrats talked to the Republicans. The Republicans weren't interested in wiping out $430 billion in student loans. And so the Democrats in both the Congress and the executive branch did exactly what tends to happen these days, which is they said, well, let's stop talking to the other side. Let's stop trying to forge a more modest compromise. Let's just call our friends in the executive branch and have them give us everything that we want through an executive order. And so President Biden was happy to comply and forgave $430 billion in debt. And the Supreme Court, after finding somebody was standing, and of course, if you impose $430 of new cost on people, it's easy to find people withstanding. But if you just give away $430 billion, it's harder to find people withstanding. But they did find one, the Missouri State Loan Processor, and that gave the court the opportunity to reach the merits. And on the merits, the Supreme Court decided 6-3 that the authority to waive or modify a regulation or a statutory provision did not give the executive branch essentially carte blanche to waive and eliminate and vitiate $430 billion in contractual debt in one fell swoop. The decision on the merits I don't think is particularly surprising. I think the court could have decided it just on statutory construction. Justice Barrett, I think, agrees with me and wrote a very interesting concurring opinion in the case that I very much recommend, where she sort of thinks about the major questions doctrine as statutory construction principle, but not really a broader doctrine. But the majority opinion does invoke the major questions doctrine, and hard on the heels of the West Virginia against Casey case, West Virginia against EPA case from last term, I mean, this major questions doctrine seems to be here to stay, and an important, I think, tool that the court is using to kind of, essentially sneak some non-delegation principles in through the back door. The court has notoriously had difficulty coming up with a test for how much delegation is too much. And I don't think the major questions doctrine is a complete substitute for that, but I do think it identifies a kind of universe of cases where there are significant delegation problems. So let me just close by talking about one other case and from last term and one case that's coming up. The case from last term I want to mention is a case I argued called Axon. There was a companion case out of the Fifth Circuit called Cochran. And the issue in the case was if you want to challenge an executive branch agency as unconstitutionally structured, as having an ALJ that's not subject to presidential removal or has an appointment problem, if you want to bring those kind of claims, the question in the case is, do you have to essentially go through the administrative agency process, suffer the exact constitutional injury you're complaining about, and only then go to the Court of Appeals? Or can you actually get into district court under 1331, bring a declaratory judgment action and say, I shouldn't have to suffer a constitutional injury before I can challenge the constitutionality of the agency? So even though the lower courts had split pretty overwhelmingly in favor of the position that now you actually got to go through the agency and then get to the Court of Appeals and forget about district court, the court unanimously held that no, that's not right, and at least when the claims are involving the structure of the agency and the like, you can go right to district court and get an injunction. And I think this is a kind of a sleeper case because by making it easier to bring constitutional challenges to agencies, I think those challenges will be get up to the Supreme Court more quickly. I think it will at least create the possibility that people can do things like argue that Humphrey's executor should be overruled and tee up that issue for the Supreme Court to decide if it is so inclined. So I think it's kind of a sleeper case. And then the case I'll talk about for next term, which I don't think is a sleeper case, is the Loper-Bright case, where the Supreme Court was handed a cert petition that offered sort of a narrow statutory question, and then a second question presented that asked the court whether it would consider overruling its Chevron decision. And the court granted cert limited to the second question. So that seems to me a pretty strong signal that the court's not interested in playing small ball here and does want to actively consider whether it should overrule the Chevron doctrine. Now, I'm representing the petitioners here, so I definitely have my kind of views on this, but I think there are a few things that the Supreme Court could do that would be better for the separation of powers than overruling the Chevron decision. I think if you look at, our founding documents, they are essentially designed, the whole point of the separation of powers is designed to constrain the Congress, Article 1, that's the branch that everybody thought might be too powerful, Madison's impetuous vortex. And yet, if you sort of look around right now, it seems like most of the important issues are being decided in the courts or in the executive branch, and most of the legislators are on Fox News or MSNBC, but they're not actually passing a lot of legislation. And I've already alluded to the reason why I think Chevron is a part of the problem here. I mean, in order to legislate, you need to compromise. If you compromise, then you get this nasty thing called a primary challenge. So legislatures, if they have an excuse not to compromise, will not compromise. And what better excuse not to compromise than the possibility of being able to call your friends in the executive branch and getting everything you want without compromising via an executive order? And of course, if you get that, then the executive order, depending on the administration, gets challenged by either Texas or California, either in northern Texas or in the Northern District of California. There's a nationwide injunction against the executive order. It goes up to the Supreme Court on the so-called shadow or emergency docket, and then everybody complains the Supreme Court's doing too much. And so it seems to me that the solution to that is to say, no, courts are supposed to interpret statutes. That's what the Constitution implicitly says, that's what the Administrative Procedures Act expressly says, and if the courts don't defer to the executive branch because the issue's difficult, close, or the statute's just silent, there's going to be much more incentive for the legislatures to actually legislate, which was the framers' design, and I think we will be in a better place than we are today. So with that, I will leave it to some questions. We'll start with Ilya.
Ilya Shapiro, Manhattan Institute. Can you explain the court's standing doctrine? Very earnest question, because I don't understand it at all.
So, at one level, yes, at one level, no, right? I mean, I think that the court, and certainly the conservatives on the court, do take standing seriously. I think they are kind of wrestling with what to do, particularly in the context of cases that are brought by states. And I think in that context, there were some decisions that I didn't have time to talk about where the court sort of seemingly cut back a little bit. And you sort of see this a little bit in the student loan case where they really focused on Mohila, that one state entity, as being the entity that had standing, and they kind of backed off some of the more extravagant doctrines that, have a little bit of, if you give a mouse a cookie flavor, because, it eventually ends up hurting the states. And so, and I guess what I would say kind of in defense of the court on this is I think what it's, it clearly has a preference for these cases to be brought in a context where the injury in fact is more concrete, that it's not going to say absolutely no to kind of more institutional litigants, but it prefers, when it's, somebody with an ox who's actually been gored, as opposed to a government entity and the like. And I don't think that's anything new. I mean, the standing doctrine has, never been pellucidly clear, but I think it's getting a little bit clearer. And, even back in the 90s, the court wouldn't consider the constitutionality of the line item veto provisions when it was Senator Byrd, but they would when it was, an entity that was affected by a regulation that was then ripped out by the president. So I'm not sure there's anything super new about this, and I tend to think it's probably, all for the good that they're kind of focusing more on, trying to isolate kind of more traditional injuries in fact.
My name is Jack Shapiro. I'm the president of the University of Maryland FedSoc chapter. My question is about SFFA v. Harvard. Given the composition of the court, I think we all sort of knew how this case was going to come out or had a good prediction. And given that, I wonder why Harvard and UNC didn't try to modify their procedures or settle just to moot this out, at least until Ed Blum sued somebody else, right? Like, try to delay the inevitable rather than taking this case all the way to SCOTUS, perhaps knowing they'd lose.
So it's a good question. I mean, I don't know that, Ed Blum would have taken yes for an answer, so I'm just not sure that's a button they could have possibly pushed. And then I'm not sure that institutionally they were in a position where even if he would have taken yes for an answer, that the faculty senate would have taken sort of, laying down as an answer. And to me, it's just another manifestation. Look, there's no excuse for violating the Equal Protection Clause, of course, but you do have to have just an ounce of sympathy for the problem that these kind of universities face, because they have lots of constituencies, and some of those constituencies are just entirely dedicated to them continuing to violate the Constitution. And so I don't think the Supreme Court telling them that it violates the Equal Protection Clause will be sufficient, but I certainly don't think they could have laid down in the absence of that. So I'm not sure they had a chance.
My name is Clement with the Washington Examiner. Thank you so much for this talk today. I just wanted to ask a quick question. You've given sort of what would happen, with the Chevron case that you're going to be leading, essentially turning Congress more into a well-oiled machine would be the a desired outcome, to actually legislate. But I just have a question, what's the upshot for small businesses, big businesses, if the fishermen were to get a favorable ruling? Can you kind of explain that? What would be the practical effect?
Sure. I'll start, though, with the caveat. I didn't promise a well-oiled machine. And neither did the framers. The Article 1 branch was sort of supposed to be a little bit of a rough and tumble exercise, but they were supposed to be wrestling with stuff. They weren't supposed to just be being sort of pundits and kind of leaving most of the hard calls to the executive branch. So I think over the long haul, I think small businesses will be much better off with a regime where Congress actually has to wrestle with things. One of the things that you get if Congress wrestles with issues is you might not love everything you get, but you do get a more durable, permanent solution than you get with an executive order that can just be ripped out the next time the administration changes. And I do think American businesses, God bless them, are pretty good at kind of adjusting even to stupid regimes. So if Congress passes a statute that's not what they exactly want, I think they'll be able to figure out a way. They'll know, okay, well, that's the answer. That's going to be the law probably for the foreseeable future. And so we're going to live with it, and we're going to figure out a way to deal with it. But to give you a more concrete example, in the interest of time, I didn't want to get too much into the petitioners in the Loper-Bright case. But boy, you don't have to look beyond the Loper-Bright case to see the implications for small business, because my clients in that case are fishermen who operate out of Cape May. They operate relatively small vessels that hold 6 to 8 people. So even Congress, and here's the point, Congress will still pass dumb laws, sure. Congress passed a law that says that they have to give up space on that ship, which is their most precious resource, to a federal monitor. But here's what happened. The National Marine Fisheries Service is not on the very top of Congress's appropriation list. And as a result, they don't have enough money to pay for monitors, as many monitors as they wanted. So with zero authorization from Congress, they said, well, we'll still keep putting monitors on your ship, and now you have to pay for them. So it'd be okay, we're going to put, an extra police officer in your backyard, and you have to pay his salary. And as we pointed out, I think it was in our cert stage reply brief, since I got a few Second Amendment cases, I've been dying to cite the Third Amendment, and so I did, and I said, look, the redcoats, we got a provision that says you don't have to quarter soldiers, but even the Brits didn't make us pay the redcoats' salary. So this is the kind of lunacy you get if you have unaccountable people imposing obligations on people. And we were talking about this at the lunch table here, but this is one of the classic defenses of Chevron is like agency expertise. Well, how much agency expertise does it take to say, well, we don't have enough money from Congress, so let's make the regulated pay? I mean, this is what you get if you unaccountable people, are wielding what amounts to a taxing authority. So I think small business will be much better off. Thank you.
Hi, my name is Ethan Yang. I'm a rising 3L at George Mason. My question is about the Harvard-UNC case. I was wondering if you had a chance to take a look at the dissenting opinions. I know a lot of people have been sharing around like snippets of Ketanji Brown Jackson's just angry words calling the justices like ostriches in the sand about the nature of racism in America, and some legal pundits have said it just kind of amounts to like a lot of just angry ranting, not a real legal argument. So I was wondering if you've been able to see like what the dissent's like real canon of interpretation or the legal theory is, because all I've been able to see is just like angry snippets and paragraphs.
Yeah, so I mean, first of all, I'll just point out it is interesting that the leaders from the student chapters are really interested in the Harvard and North Carolina cases. That's shocking. The second thing I will say is, I'm not going to say I've been through every word in every one of the separate opinions in the affirmative action cases. I've certainly read snippets of them, and I've read parts of them. I kind of think that this is all kind of overblown a bit, and I mean, the dissent has its theory about the affirmative action clause, which isn't that radically different from the positions that the more liberal justices took in sort of cases like Gratz and Grutter and all of that. So I don't know there's anything sort of super new there. I think Justice Jackson, in some respects, kind of dropped some of the sort of pretense about what this is all about, and made quite clear kind of her views about the need for these kind of programs, and they need to not have a stopping point and all of that. So there are aspects of the dissenting opinions that very much take issue. There's been a lot of focus on the sort of Jackson-Thomas kind of back and forth. Look, you're talking to a Scalia clerk, and some of the Scalia-O'Connor back and forth back in the day, in baseball terms, was some pretty serious chin music. That happens, and it particularly happens at the end of terms, and it particularly happens in cases where the justices care passionately about the results. I don't think it's really anything more than that. There's also a lot of talk about sort of the Chief and Kagan in the student loan case and some of the back and forth there. And as I say, I think that's not that atypical. It happens. It happens in June. They come back in October, and then they decide, 20 or 30 cases unanimously. So I think it's a little bit much ado about nothing.
Thank you.
Celerina Lopez, interning with the National Federation of Independent Business. As an aspiring attorney, I'm curious to what your professional opinion is on imposing term limits to the Supreme Court justices and modifying the nomination process.
So, all I can say about that is, I think that, if you look at the framers' design was to have the court play a, very limited role and decide cases and controversies. They didn't expect it to be the body that would decide all of the most contentious issues in our society. And so if you kind of understand that, my sort of first preference would be to get us back to kind of the framers' design where, Congress is doing a little bit more to resolve some of these issues. The Supreme Court is deciding cases it should decide, but it's not getting into issues where the Constitution is, so silent that the D.C. Circuit would give it Chevron deference, right? There are issues that are contentious that the Supreme Court says nothing about. There are issues that are contentious that the Supreme Court addresses specifically. Gun control is a controversial topic, but we have a Second Amendment. But other topics are very controversial, and the Constitution is silent. So if you get back to the framers' design, that's like the first best solution. Now, if you just can't get back to the framers' design and you sort of give up, and we're going to have sort of, a permanent institution where 9 unelected people are going to decide the most contentious issues in society, then, yeah, if that's what I'm stuck with, I suppose I prefer term limits. But that's kind of giving in my view. I mean, that's, maybe that's the second best solution, but it's not the framers' design, and it's not the first best solution. So, I'm an optimist, and I think, and I think many of the justices, some optimists, some pessimists, but they're very dedicated to kind of getting back closer to the original design. So I guess my answer would be, as long as that's possible, then that's got to be the preferred option.
Thank you.
Hi, Stanley Cook, a retired U.S. government. You mentioned 2 cases in the civil rights reapportionment area which were decided by the liberal group. If I'm informed correctly, there's another civil rights case on docket for the next term. Can you tell us anything about that?
So I assume you're talking about the testing standing case?
That could be.
Yeah, no, there is an important, case, and it gets back to Ilya's question about standing. So there is an important case, the way that, it's a lot of civil rights litigation is done is through so-called testers who, go into a business. They have no interest in actually like purchasing a product, but they want to see whether they'll sell the product to somebody of a particular race or in particular circumstances. And then if the business sort of, doesn't engage with them in a way that arguably violates the law, then they'll sue the business. And so the question the court's going to wrestle with is, does that kind of case, does that kind of tester standing satisfy Article 3? And I think it's a very interesting case. I try not to venture guesses on cases where I haven't read all the briefs and I don't even think all the briefs are in. But I actually think that case will be, relatively difficult to predict.
Thanks.
Hi, I'm Randy Quarles. I'm a rising 2L at Chicago and an intern at the New Civil Liberties Alliance for the summer. You mentioned briefly the standing issues in the student loan case and the difficulty of finding someone who had standing to challenge it. And it seemed from what I followed as that was happening that was an intentional process to try and limit the standing exposure of the executive order. I'm wondering if you think that sort of standing gamesmanship is going to become more common in the future as the executive orders continue to be issued, and how you think the court will respond if it becomes more explicit.
Yeah, so it's a great question, and what I would say is, like, for the most part, I think it's hard for the executive branch to sort of do an executive order in a way that sort of, cleverly denies people standing. And because, most executive orders, like the whole point of doing it is to kind of, impose some legal rule on people, and as a result, there should be people with standing. But there are a class of cases, and whether coincidentally or not, this problem seems to be more of a problem for challenging executive orders of Democratic administration than Republican administrations, because the orders that are hardest to figure out who's going to challenge are the orders that have the appearance, at least, of taking the form of executive grace. So we're not going to impose some new obligation on you. We're going to take some existing obligation, in most cases an obligation imposed by statute, but in the student loan case it would be an obligation imposed by a combination of contract and statute. But we're going to take some existing obligation and we're going to make it go poof. And and President Obama did this kind of famously when the implementation of the Affordable Care Act got sort of tough. So, all right, employers, under 100 employees are having trouble with this. Let's just make 100, 200. And you ask yourself, all right, like, who's got standing to challenge that? And it's not as super obvious, right? Like, whereas if the statute said that you have to do this if you have 100 employees, and you say, it's a good idea for companies with 101 employees, it's a good idea for employers with 99 employees. So even though the statute says 100, we'll start imposing it on employers between 50 and 100. Well, every one of those businesses immediately has standing, and there's no issue. But if you start relaxing statutory requirements, like the party that just got its obligations relaxed doesn't obviously have standing. You might think that the business next door that, it still has the burdens and is just like 3 employees differently and is supposed to be treated the same by Congress might have standing. But those are much harder questions. But so I don't think it's like something that just like across the board that the executive branch can try to insulate them. But there is a particular universe of cases And I do think, it doesn't make a lot of sense if those kind of cases can escape judicial review, even if the injury is a little more subtle. And so I think that'll be an issue maybe the court has to wrestle with in some other context when they don't have MOHELA available.
Thank you.
You bet. I think one last one.
Thank you. John, Rising 2L at Columbia, also with the New Civil Liberties Alliance. My question's about administrative regulation, specifically what you think about policy arguments against administrative overreach, the idea that agencies and the regulations often benefit maybe industry players, large industry players, factoring the revolving door, and maybe that large players can better afford the cost of compliance, and it's good for keeping out competitors. Whether you think these kinds of policy arguments are accurate, whether they can be used in litigation, and whether they should be used more, or whether you think they're overstated.
Yeah, so I mean, I do think that I think they're both accurate and probably like slightly overstated in the sense that I don't think all agencies are created equal from this perspective. I'm not seeing a lot of big companies right now that have captured the FTC. So I think it depends a little bit on the agency. And I also think this is a context where you really do see that the administrative state almost has a disproportionate negative effect on smaller businesses. Because maybe if you're a really big company who's a repeat player in front of an agency, then you can essentially sort of afford to put the resources in to kind of lobby the agency and work with the agency. Whereas if you're like my clients in the Loper case, and you're barely making ends meet, you don't have money to go lobby sort of an executive branch agency in Washington to sort of come your way. There's another piece of this that's actually pernicious too, I think, that's related to it. So maybe this is like the next policy argument, and you guys are doing great work, so I'm sure you're on it. But there's also, at the same time, there's kind of captive sort of, the ability for industry to capture the agency. There's also a lot of skewed incentives, though, for those same companies to actually challenge the regulators. And so, there are circumstances. If you take an agency like the FCC, the Federal Communications Commission, there's some companies that occasionally get in front of there, and if they see an outrage for the way the commission is proceeding, they might actually file a lawsuit, because they can actually afford to file a lawsuit because they're not regulated extensively and they're not sort of quote unquote suing their regulator. Whereas the companies that, on the one hand, maybe they're capturing the agency, but on the other hand, it's very hard, I've tried, to get some of these companies to sue their regulator. And I think that also has probably a negative effect on kind of the development of the law. And it'll probably be easier, if we get rid of Chevron, it'll probably be a little easier to get sort of affected people, to sue the government for the statute as opposed to suing their regulator all the time. So that may be another sort of side benefit.
Thank you.
Cool. Thanks. Thank you very much.
So Paul, that was brilliant. Thank you so much for being with us today, and thanks for all the time it took to prepare that. And I'm sure you'll redo it for our chapter in Milwaukee. We have a long tradition in this chapter of giving our guest speakers a signed copy of the Federalist Papers. It sort of feels to me like you've already read it. Maybe have a copy of your own. So instead, a different way to spend a nice evening. This bottle provided by Reg Brown. So he was here in spirits.
Thank you. Thank you. I'll thank you.
Thank you all.